Hello, good afternoon, everybody. How are you doing today? I hope you're doing good. My name is Juan Carlos Brando, and today I'm hosting the show with one of the attorneys in the law firm of Margaret W. Wong and Associates. And the attorney Margaret W. Wong here is today in Atlanta, so she's quite busy, and we're going to have one of the awesome attorneys in the law firm, which is the attorney Allison Chen. She is going to be answering your questions today. So if you have any questions, please write them down, and we will be answering them throughout the show in this afternoon. So let's welcome the attorney Allison Chen. How are you doing, attorney? Thank you
I'm
so
good.
much for having us.
Thank you for having me.
Okay, so let's start by talking about what's going on in the immigration field. But what about talking about these notices that never get into the file that are called off docket notices? What happened with these notices, and what happens if I don't receive one or some of them?
Sure. So I wanted to talk about this off docket notice, which really was a program that started late last year in, I think, 8 immigration courts around the country. And it's now expanded in the last couple of months to all the immigration courts. It is called a notice of intent to take the case off the court's calendar. You'll receive this, your lawyer may receive this notice. It is not issued by the local immigration court, but instead by headquarters, National Immigration Court, Immigration Court headquarters in DC. And they are issuing these notices to try to clear some of the calendar for these judges. There's over 2 million cases in immigration courts around the country, and there is just not enough judges and not enough immigration courts to be hearing all of these cases efficiently. And then plus you have the border situation, so there's a lot of people migrating across our southern border, and then some being placed in immigration proceedings, and with the end of Title 42, they expect a lot more in immigration court. So what they're doing about this is sending out some of these notices to take current cases in court off the calendar. What does that mean? Right now, these cases are currently scheduled. You may have something called a master calendar hearing, or you may have an individual hearing. The master calendar is like a pre-trial hearing. It's a shorter hearing to talk about what you intend to file and to go through a procedure called pleadings. And then the individual hearing, which is your final hearing date, may also be scheduled after that. Whatever type of hearing you have, this notice may be sent to you to give you an opportunity to postpone your case, an opportunity for them to cancel your case so that you don't have to go to your master hearing that's coming up or your individual hearing coming up. That could be good for some people, and it could be not so great for other people. But let me tell you who these notices are being sent to. These notices are being sent to people who have generally other petitions pending outside of courts. So for example, if you are married to a U.S. citizen, you have an I-130 pending, or you have a child over 21, there's an I-130 pending, a petition that family relative filed for you, you may get it. They specify, which category you fall under when you get this notice. If you are someone that has TPS or is eligible for TPS, then you may get this notice. If you're a person who is a child that is seeking a custody order outside of court that would get you a special immigrant juvenile status, you may also get this. Other people that are getting this are children who have applied for asylum with USCIS and may not need to have their court proceedings heard so quickly because they had that other asylum application with CIS. Other people that are getting it are people who have cancellation of removal of 42B application, a hardship application pending with court. So if you are one of these people that have one of these applications pending and you have a lawyer, you may want to check with that lawyer who may have gotten a notice of intent to take the case off the calendar. What that does is it cancels your next hearing date. you will still be eligible for, if you have a work permit now, likely you'll still be eligible for that work permit, to renew that work permit. What it does for the court is it frees up a calendar space, and what it does for you is it allows you more time to develop your case. If you need to get more medical records, if you need to get more documents from outside the country, if you just need more time to have your case heard, maybe your case isn't very strong right now, they could take this case off. So what the court is doing is they'll give you 60 days from the date the notice is issued to let the court know whether you want to keep your case as scheduled, or if you don't do anything, if you don't respond, they're going to automatically cancel your future hearing date, but your case will remain in court. Okay? Juan, does that make sense, what I explained? It really belongs
Yes.
to a very small subsection of people, but it's very, very significant because a lot of people in court are starting to get these notices.
So, what would happen with those people that have been waiting for, let's say, a court hearing for 2, 3, 4 years? Are they going to have a faster time to the hearing, or they are going to remain the same, but the new ones are going to be taken care of faster by the Department of Justice?
Right. So if you decide not to respond and they take your case off the calendar, they cancel your next hearing, you can keep renewing your work permit. We don't know what will end up happening to these cases that were taken off the calendar. There's thousands, maybe tens of thousands being taken off the calendar. Eventually, you will have your case heard. I don't know, under this administration, maybe the next administration, until this program ends or there's a change in policy to put all these cases back on. Your case will just have no future hearing date. You don't win your case, you don't lose your case. And then for other people who did not get the notice and still have their court hearing, it's probably because they haven't gotten your case, or they're not aware that you fall into one of these categories. You may have a faster hearing date. I mean, I've had 3 hearings this week, master calendar hearings, and I could see they were all over the country. They were in Kansas City, they were in Florida, and another one in Virginia. All of these cases were set for final hearing dates next year in 2024, which is very surprising to have such a quick case heard. Now that they're clearing some of this docket, it makes room for a lot of other cases to be heard much faster. So it's good for some people, it's not so great for other people.
Okay, thank you so much, Attorney Allison. And if you have any questions, please don't forget that you can call. The phone number is 216-279-3984. 216-279-3984 is the phone number that you can call to get in touch with one of the attorneys in the law firm of Margaret W. Wong and Associates. 216-279-3984. 216-279-3984. We have some questions coming in, and this first one is, my wife had voluntary departure in 2018. We did the I-130 before and it was approved, but then she got stuck there. What do we need to do to bring her back to the United States?
Okay. So there's a couple of cases going on, or a couple of things going on here, and I'm sorry your spouse is stuck. Generally, when you take voluntary, I don't like my clients taking voluntary departure if they don't intend to leave on time. So when you say that your wife is stuck, I wonder if when the immigration judge granted voluntary departure at court, they usually give you a specific time to leave. It's valid until a certain time. So I wonder if your wife left on time. And if she did, then she should be okay to come back and file an immigrant visa and come back, as long as there's no other immigration violations. If she did not leave on time, and on time, the judge usually gives an expiration date for when you can leave. If she didn't leave on time, then she could be technically stuck there. You may have to reopen the case and see if you could rescind that voluntary departure order, but that's very difficult to do. If you don't leave on time with voluntary departure, then it turns into a removal order, but you also would be barred from receiving immigration benefits, including an immigrant visa, a green card, adjustment of status for a 10-year period. So you're stuck unless you can reopen that case. So I would really try to call an immigration attorney to look at when was your, you said that the VD was voluntary departure was in 2018. Who issued that voluntary departure? Was it a judge, or was it at the border with DHS ICE officials? And whether she left on time or she didn't leave on time.
Yes, so this person is actually sending us the other part of the question,
Mhm.
and says she left on time because the judge suggested no punishment if she left on time.
Right. Great. Good. I'm glad that she left on time. Then the question is, why is she stuck? And you should be able to bring her back on an immigrant visa application. So just because it's approved and you left on time, you still need to go through the application to file for her green card. The I-130 is just the relative marriage petition. The second part is to file the immigrant visa application. You need to transfer the I-130 visa petition, the marriage petition, to the Department of State, the Visa Center. The Visa Center at that time will issue you an invoice to pay the fee bills. You file the immigrant visa, the DS-260 immigrant visa application, and all the paperwork with the Visa Center. At that time, the Visa Center will review all the paperwork, put together the file, then eventually transfer that, complete the file and transfer it to the U.S. Embassy. The U.S. Embassy will then issue a immigrant visa interview at her nearest embassy. For her to come in, you'll have to do biometrics, fingerprints, you'll have to do a medical exam and go in and answer questions. And then once she passes that interview, they'll issue the visa in her passport, and then she uses that visa to pay another fee and then come back into the United States. So I hope that answers your question. It is a little bit, you have to maneuver a lot with some paperwork. After that I-130 is approved, you'll need to make sure that you get the visa set NBC visa fee bills to start that process. If she then gets still stuck after she files the immigrant visa, then you really need to see a lawyer to see if she's eligible for any waivers, if maybe they're charging her with other immigration violations, since she did leave on time. I hope that answers the question.
Okay, thank you so much, Attorney Allison. And don't forget that you can call. The phone number is 216-279-3984, 216-279-3984. Attorneys in the office of Margaret W. Wong and Associates. They have over 46 years of experience working in the immigration field, and the attorney Margaret W. Wong and her team have helped thousands and thousands of people every single year to get an immigration relief. So please write down this phone number, 216-279-3984, 216-279-3984. The next question says, why some states don't approve special juvenile status for if the kid is living with their mom?
Okay, that is a very good question, and a lot of people, it's a little bit complex with the laws behind it, but so immigration laws is a federal law. Now, states have their own state laws. So immigration has a law that says that you are eligible for special immigrant juvenile status as long as you can show that the child was abandoned, neglected, or abused by the parent, and that there's no reunification with that parent, one or both parents. This one or both parents has been litigated a lot because, and I know I'm here in North Carolina, and there is, you are allowed to pursue that. There's been litigation on it, and you are allowed to pursue it if there's one parent. But in some other states, it's very difficult because based on the state law, some courts cannot grant it. And then immigration will look at that state law and have conflicts between the state and the federal law. So it depends on what county you're in. It depends on what state you're in. It depends on what the judge will decide at the state court level and how immigration will interpret whether that reunification status will hold with one or both parents. So that's why, because there's just conflict between the federal law and the state law, and whether that state will recognize reunification, abandonment, neglected, and abuse. Are you really abandoned, neglected, and abused if you're still living with one parent versus both parents? Okay, so I would look at speak to an attorney and see whether that predicate child custody order at the local level can be approved if they still live with that one parent.
Okay, thank you so much, Attorney Allison. Don't forget that you can call the phone number 216-279-3984. 216-279-3984 is a phone number that you need to call. The attorney, the office of the attorney Margaret W. Wong has locations in 7 cities of the United States, in Atlanta, Chicago, Cleveland, Columbus, in Nashville, New York, and Raleigh, North Carolina. And you can just call the phone number 216-279-3984, 216-279-3984. We have the next question coming in through our YouTube channel. And this question says, what are good reasons to expedite a family petition? My son was raped in Mexico when I went with his dad waiting for his case to be approved. And also we are having financial hardship, I guess, in the United States.
Okay. What are some, my son was, I'm so sorry to hear about your son in Mexico. So I'm assuming that there is either an I-130 family petition pending, or the child is waiting for the immigrant visa to be approved based on that approved family petition, and they're just trying to expedite. You can expedite certain cases depending on what stage that case is in. So if it's an I-130 that you're waiting for an approval for, there can be, the son was born in the US, but we moved to Mexico because the dad was deported. So the son must be filing for a parent then. I think that might be it. But if the child is filing an I-130 for the parent and it's with USCIS, you can file an expedite request by calling the 800 number with USCIS. They will consider certain humanitarian circumstances to make the request. They will consider financial hardship, but you will have to first call, say you want to make an expedited request, and then tell them the reasons why. If you have an online account with USCIS, you can also make it there, and then you can upload documents of financial hardship. Generally, I would submit all the humanitarian circumstances you can. So if there's medical records, letters of support, financial documents to show that they're suffering in that home country and that they need to come back. I would file all of that with USCIS to try to get that expedited. These are very difficult to get expedited because in USCIS is very slow in the first place, and everyone's trying to get their case expedited. So I would call USCIS and discuss like the humanitarian considerations and the financial loss to your family.
Yeah, so this person is adding that they are now living in the United States, but they want to bring their dad back to the U.S. because they are having financial issues. It's what it looks like.
Right. So I would call USCIS, because if they're here and the family relative is overseas, you would have to call USCIS to expedite that request.
Okay. Thank you so much, Attorney Allison, for this answer. And don't forget that you can call 216-279-3984. 216-279-3984 is the phone number you need to call in order to talk to one of the attorneys in the law firm of Margaret W. Wong and Associates. The next question is, how can I apply for NIW visa? I am a civil engineer from Colombia.
Sure. This one is maybe a little bit harder for me to answer because I mostly focus on family and removal. NIW is a national interest waiver green card, and you have to show that you hold an advanced degree and that you're an individual with exceptional ability in the sciences, arts, or business. And so that would require that you show 3 out of 10 circumstances that they list online. I would probably definitely refer you to an attorney, and our office does handle those, and we can absolutely talk to you about whether you would qualify, whether you're here already and want to do a change of status, or you're in Colombia right now and want a consular process that visa. We can help you. I think the first step is to make sure you gather your documents and provide a CV to us to see if you would qualify for the NIW, because you do have to show that you have this exceptional ability, and there's qualifiers for that, and you have to meet several of those and convince immigration that you meet that level and that you have that advanced degree. So I would say the first step is to develop your CV and show us your CV, and we can look to see if you qualify for that, and then maybe look to see in which areas you can kind of develop a little bit more.
Okay, thank you so much, Attorney Allison. Don't forget, the phone number is 216-279-3984, 216-279-3984. If you need more information about these kind of cases, we know it's something interesting, and there's a shortage of some kind of professionals here in the United States. So please call the office if you can do it from wherever you are. And the phone number is 216-279-3984. And they will be happy to give you more information about this kind of visa. Okay, let's go ahead and get the next question. It says, is it a bad time for the 10-year cancellation law? I have been here for 10 years and want to do asylum, have 2 kids born in the United States.
Sure. So I want to explain a couple things. 10-year cancellation is, I think what they're referring to is a 42B applications called cancellation of removal for non-permanent residents. So those are applications that you can qualify for, and if granted, you would receive a green card, a lawful permanent residence. If you've been here for more than 10 years, you are a person of good moral character, you don't have any disqualifying criminal convictions, you don't have any serious criminal convictions, and you have a parent, spouse, or child who is a green card holder or a permanent resident. The child has to be under 21. And you can show that that qualifying relative will suffer exceptional, extremely unusual hardship. Now, that is an application that can only be filed with the immigration court. And so not everyone, I mean, a lot of people seemingly are eligible for it because they've been here for more than 10 years. They have a child or a relative that would suffer, and they have good moral character, they don't have serious crimes. But you can only file in court. So, and you don't really go to court unless you're arrested or you're referred to court. So a lot of people want to apply for this, but unfortunately, you're only eligible with the judge. This person specifically says, I want to do asylum. Asylum is a different application that you can file if you're afraid of being persecuted, if you have been persecuted in your home country, or you're afraid of being persecuted if you go back. You're generally eligible for asylum if you apply within 1 year, unless you can establish some type of circumstance why you didn't file for 1 year. So I imagine if you want, that person may have you want to file for asylum. Maybe you had something, suffered persecution in your home country. You want to file for asylum. Maybe you've been here for a long time. You're going to have to establish some type of exception why you didn't file within that first year, because then otherwise you wouldn't qualify. If you are able to establish that exception, or you have a good reason for why you didn't file these years, you can still file for asylum. It's very difficult to win asylum. When you go to that interview for asylum, they'll assess whether you have met a circumstance overcoming that delay. And if you have, then you could potentially be granted asylum. But if you're not, then you would be referred to court. And I think that's where the person may be thinking, well, if I then go to court, then you could file for cancellation as well. You would then be eligible for that, but you would also renew your asylum application. So now, is it a bad time? Is it a good time? It's, that's hard to say because it just depends on the strength of your case. The cancellation of removal application, you can succeed and you can win on that if you can show the exceptional, extremely unusual hardship to your relative. That's not just regular hardship, it's not extreme hardship, it's the highest standard. It has to be substantial hardship. So generally, kids who have serious medical conditions, behavioral problems, mental health issues, spouses that have a lot of medical issues, parents that are aging and have a lot of problems, and you support these people, those could be very good cancellation cases. But I would not, just file an asylum or just file for cancellation, especially if you don't have that hardship that you can show, because otherwise, I wouldn't want it to result in a denial, and then you could be ordered removed by the immigration judge.
Okay, thank you so much, Attorney Allison, for this answer. And yeah, a lot of rumors are going around, and we just need to talk to the right person, because I can say my friend told me that I can do this, or a friend of mine got his documents, and some people, I don't know how can people believe some information and just consider of doing something just because someone said that they could do it, and then
Right.
they get in trouble, and so much trouble for them if they are doing it by themselves. So please, before you do something related to immigration, please make sure that you talk to an attorney. And what could be best than talking to the attorneys in the law firm of Margaret W. Wong, that you can just make a call or wait for this show every week, and you can ask your question and get an answer for free. So please keep this number in mind, 216-279-3984, 216-279-3984. Next question says, I suffered assault in a hotel while working. I filed a U visa and got approved after 6 years. Now I would like to apply for a green card. How long would it take? But also, this person says, I really need to go to Mexico to see my dad. Can I do it now with my U visa?
Yes. So you need a travel permit. So once you're approved the U visa, you definitely need to do not travel without getting a travel permit. You need permission to travel. Okay. And so that's number one. Number two is, if you would like to apply for a green card, you have to wait 3 years until you're eligible for that, to apply for that green card. Then once you file for the green card, it could take 9 months to 1.5 or even 2 years to receive the approval of the green card. Okay, so I hope that answers that question.
Okay. Thank you so much, Attorney Allison. And yeah, our time is up for today. Thank you so much for all of your answers, for sharing your knowledge about immigration. And please, let's keep in touch every time that we need to do the show. It's awesome to have one of the attorneys that really, really know about immigration. So thank you so much, Attorney Allison, and see you next time.
Thank you so much. Bye-bye.
Thank you. And don't forget that you can call. The phone number is 216-279-3984. 216-279-3984 is the phone number that you need to call in order to talk to one of the attorneys in the law firm of the attorney Margaret W. Wong, with over 46 years of experience and over 12 or 15 attorneys working for you in the law firm, going to the immigration court, filing your cases, helping you in your immigration case, and not forgetting about any dates, because immigration is based on deadlines. Deadlines are very important in immigration, and you need to meet all of them, not to get in trouble or getting deported by immigration. So keep this phone number in mind, 216-279-3984, and make your call as soon as possible if you need immigration help. Thank you so much. See you next time. Have a good lunch. And it was a pleasure to have all of you today joining us.